Community Environmental Legal Defense Fund, CELDF, is a non-profit public interest law firm providing free and affordable legal services to communities facing threats to their local environment. Its technique is to help individual communities assert their right to local self-government and to recognize the rights of nature. This may sound dry, but it involves organizing, educating, and nurturing local groups in scores of municipalities, groups made up of ordinary citizens who have discovered to their shock and horror that their democratic communities are the playthings of corporations which have rights that mere citizens don't have. CELDF has assisted more than 110 local governments, not to mention the governments of Nepal, India, and Ecuador. CELDF was a founding member of the Global Alliance for the Rights of Nature and a co-author of the Universal Declaration for the Rights of Mother Earth. Thomas Linzey is the organization's visionary co-founder and executive director, and Mari Margil is its incisive associate director. I've been a big fan of their organization for many years, so it was a great pleasure to sit down and talk with Tom and Mari about the way that CELDF is changing America and the world one town at a time. Your work seems to come down to the right of the legal right of a community to say no. Is that a fair description of the core of what much of you do is?
I think somewhat. It's where we started the work of the Legal Defense Fund, which was we had communities that were faced with toxic waste incinerators and factory farms and sludge dumping and fracking and all kinds of thousands of different single issues that communities face every day on a daily basis. And what we found about the U.S. system of law, and now over the past 10 years we found about other systems of law, like the Australian system of law and Canadian system of law, even in some ways the Nepalese system of law, is that communities have been cut out of having any kind of authority over whether certain corporate projects come into their community or not. And they're, in essence, in the U.S. and other places, have been under a structure of law in which they can't say no to any of these things coming in. And the reason why they can't say no can be tracked back to certain corporate legal doctrines which have emerged and been transformed over the past 150 to 200 years in the U.S. at least. And it's basically put communities in a box where they have these legal doctrines on each side of the box that if they attempt to say no, say fracking's coming into your community, if they attempt to say no to fracking coming in, that the corporation that's affected by that frack project actually has recourse to a system of law that allows them to punish the municipality for even attempting to say no. And so, as strange as it may sound in a country where people talk about democracy, is that no democracy exists in our municipal communities today because communities can't say no to these things coming in. And if you can't say no to a big box store coming into the community, you can't say yes to a viable downtown. If you can't say no to Smithfield Foods Corporation coming in to put a 20,000 head hog factory farm in the middle of your community, you can't say yes to sustainable agriculture. So, if you can't stop fracking, you can't say yes to a sustainable energy future, because if you can't stop the bad things from coming in that are interfering with your vision of what sustainability should be, then you're in a position where you can't define the future of your community. And so it's been fairly controversial work, I think, in the United States and fairly confrontational. But at this point in the US and these other countries, that sustainability is illegal. That to even move in a direction of sustainability is stopped by the law. And so when we use the word economic and environmental sustainability is illegal, it's that it's been made illegal by these structure of laws that are in place that communities are forbidden from saying no to these projects coming into their municipalities.
How does that work? How can that be that there's a kind of a blanket prevention?
Well, the blanket prevention exists because we have doctrines like preemption in the States and to other extents in these other countries. But the way preemption operates is that the corporation in a given area, like the energy industry, goes to the state government or to the federal government and puts a law in place that forbids municipalities from adopting anything different than what the state or federal government has put into place in terms of a regulatory framework for those corporations. In addition to preemption, you have something called corporate rights. It always sounds strange to people, but corporations have been bestowed certain constitutional rights in the United States and Canada and Australia and these different places where we've worked, in that corporations can sue municipalities, can sue communities for violating their corporate constitutional rights. So we're used to people having constitutional rights, that we have free speech rights and due process and equal protection and other rights. But starting in the early 1800s and going back into the 1600s in England, that courts and systems of government have recognized corporations as having the same constitutional rights as persons. And the reason why that matters in this case is that one of those rights are what are called Fifth Amendment rights in the United States, which allow corporations to sue communities for taking corporate property. So if the state has issued a permit to say you can frack here, and the community says no, you can't, then the corporation has a cause of action against the municipality for damages to pay them for the cost of not being able to frack within the community. It's created a constitutional right to frack on behalf of the corporation, so they have a constitutionally embedded right. Whereas us, people in those communities don't have a right to say no. The corporation has a constitutional right to frack, or a constitutional right to put in a factory farm, or a constitutional right to do all the bad things. And so when we say sustainability is illegal, it's because there are these reinforcing doctrines in place that basically put the community in a cage. And as activists, we've heard it's sexy to talk about, well, it's time to rattle the cage. Well, it's not time to rattle the cage, it's time to break the cage open, because rattling the cage is actually trying to ask others to fix your situation for you. We're in a cage, we want more food or more rations or more water or whatever you're asking. But in this case, that cage has been carefully built so that we have no control over big issues that deal with energy and agriculture and transportation even. And these huge single issues, these huge areas that have been put off limits to our communities to decide what happens in those areas. This work, the work that the Legal Defense Fund does, is really about busting open that cage to say that we have a right to local community self-government in our places where we live. And that includes making decisions about agriculture and energy, and includes making decisions that are in those areas that have since been privately reserved to corporate actors to build energy policy or agricultural policy or transportation policy or whatever. At least in our opinion, we can't get to sustainability. There's no way to get to sustainability by changing light bulbs and taking shorter showers and composting. I mean, those are all good things, but they're not going to get us to the place where we need to be, because they admit, in some ways they validate the fact that we have no lawmaking power in our own communities to actually use the system of law to get to environmental and economic sustainability. And if that remains the situation, we're pretty much cooked.
I think our communities, it helps to understand, they ask us, well, why is the structure this way? It doesn't seem logical. And it certainly doesn't seem to be of we the people. And communities, I think, come to an understanding, as we have, which is that the structure of law is set up this way, as Thomas has been describing, to aid interests other than our own. And those interests are a constant, endless expansion of development, of growth, of extraction, to aid that. So the structure has been designed to make sure that that progress, as many choose to define it, that endless growth and development as progress, as making sure that that continues unimpeded, so that communities can't interrupt that flow of development and extraction. And so the structure of governance has been, and law has been, to make sure that communities and activists can't interfere with the flow of that, or the flow of commerce, as many would define it. And so the structure has been designed that way, and it means that communities have been subordinated to the point where they really can't decide anything. Because if they do, they would interfere with the ability to frack or to mine or to drill. And so if we gain an understanding of why would the structure ever work this way, if we understand that the structure is actually designed to ensure endless growth, what Richard Grossman, a historian that helped to develop our democracy schools and our theory, he described it as the endless production of more. Just more what? More stuff, more everything. And if we understand the structure of law to be designed to ensure endless production of more, then it makes sense that it would be designed to make sure that happens and to keep everything else out of the way.
So the question is, can we build sustainability by leaving those doctrines on the table? For the past 50 years, we've said the answer to that is yes. Environmental activists and labor activists, you can leave that basic structure on the table and then try to work around it, which all of our stuff for the past 50 years of environmental activism has been working around it, accepting that as the structure, and then working around it to do things like permit appeals. State issues a permit for fracking, so we go and try to appeal the permit. But when we do that, we're operating under the rules that were written by the corporations that ostensibly the regulatory system was supposed to regulate by that permit system. So we're working under somebody else's rules. And the whole premise of our organizing is we have to get rid of those doctrines. We have to liberate or free our communities, because until decisions are made by those impacted by the decisions coming in, the projects coming in, until people that are actually impacted by those projects are the ones making the decisions about whether they come in or not, that we will never have sustainability, because there's no interest in Dutch Shell in sustainable communities, or by Smithfield Foods in sustainable communities, or Monsanto in sustainable communities. Their job is to come in and extract. Their job is to take, whereas the community's job is pretty much to keep, preserve, and conserve. There's two different value systems there, and the law is on that value system, not the community value system at this point. So the question is, how do you occupy the law to actually change how the law operates so it supports the communities rather than supports the extractive interests?
It's interesting you use the word occupy. It occurs to me that this is the Occupy movement in a legal framework almost. You know. But the taking doctrine is also, just before we move on to other things, there's something quite bizarre about this, because the fundamental principle there is that the corporation gets compensated for purely imaginary profits, right? For profits that they weren't allowed to make because of the presumably unreasonable objections of the community. It seems to me the trade deals have now extended that, so that we're increasingly in a world where our nations are not allowed to interfere with corporate activity.
Yes.
Right? And it's the same doctrine, isn't it? It's purely imaginary profits, right?
Yeah, except the law doesn't treat them as imaginary. I mean, the fact is...
No, we're talking about real life.
Yeah, If the corporation has a lease to extract within a community, and they can calculate how much gas they're going to be able to extract through that lease, and then the community comes in and says you can't, and bans the fracking. Corporation then says, well, hey, we have the lease, it's in property interest, and the fracked gas is our property, and we would have pulled out $2 million worth of gas from that deposit. That then the lawsuit comes against the municipality for that amount. And so the law treats it as a very real interest, not imaginary. Even though the community says we want to leave it in the ground, doesn't matter, because the law doesn't see the community's interest at all. And so with the trade agreements, it's the same deal. It's the MBTE stuff, or the other issues that have come before the trade tribunals, NAFTA and GATT, and there are new trade agreements that are now being negotiated. But all of those see commerce as the overriding value, and community protection as a lesser value, which, not surprisingly, perhaps to some, is the same structure that the U.S. Constitution puts into place. We have a constitutional structure that was adopted in the 1780s, and that constitutional structure was about putting the rights of commerce and property above the rights of communities, people, and nature. That's how it's written, and when you read it, it's hard to see anything but that. And so, the founding fathers didn't understand deforestation, didn't understand acidification of the oceans, wouldn't have understood climate change. They saw an endless bounty of natural resources on the horizon, and they saw their job as helping to exploit that bounty, because that's how you became a major power. So you didn't have to worry about getting invaded anymore, was to build a major power, and that liberty and progress all flowed from that property transformation, the exploitation of resources and making them into useful products. That was their mindset in the 1780s. We have an archaic constitutional structure that places certain property and commerce rights above everybody else's. And we can either try to live with that structure, which we have, in the past 60 years of activism, working around it, or we can change it. That's the option. And we're to a point, in the communities we work with, they're to a point where they have begun to understand that constitutional change is necessary, not just the community change, but the community change has to begin to inform and force the constitutional change higher up. So I think we're seeing nothing less in the United States today than a push towards major constitutional change that actually seeks to put sustainability as the overriding value, rather than protection of property and commerce, which it is today.
But given the malfunction of federal governments in a number of countries, certainly Canada, the United States, Australia at this point, not a very promising environment for constitutional change. So you were talking, Mary, when we last met, about doing it from the bottom up. Tell me about that, because that was a very fruitful thought.
Well, there's two things that are happening in our communities. One is that communities are finding that they're being threatened by fracking and mining and what have you, and that they don't have the authority to say no. We've, through our organizing, and our communities have bumped up into a lot of walls. Their walls being their elected officials at the state legislatures. They go in and they beg and plead for help to try to protect themselves from fracking. When a community, for example, calls in New Hampshire, where we've worked with a lot of communities that are facing the privatization of their water by corporations that want to come in and stick a giant straw into their aquifers, siphon off millions of gallons of water a day to bottle and sell. And communities call up in New Hampshire, it's the Department of Environmental Services, and say, hello, our state environmental agency, can you help us to protect our water? And what they find instead is that instead of their own government helping to protect their water, they're legally authorizing the corporations to take it. Which is to say, it's an example, and it's the same way across the United States, whether it's on water privatization or fracking or factory farming, that communities are looking to their state elected officials and their state environmental agencies for help to protect their water and their communities, and instead are finding that their state governments are working for interest other than their own. And so they've bumped their heads into their state government, and very similarly, they've bumped their heads into the United States Congress, which has been basically stuck in no-go zone for years on protecting the environment. And so communities are coming to the conclusion, and we've come to the conclusion with them, that the only place right now in the United States where we can make change is at the grassroots level. And that comes from a lot of lessons that we've drawn from past people's movements. We teach something called democracy schools, these weekend trainings that communities host. We've held over close to 300 now across the United States, and we've had some in Canada as well, in which we look at these past movements and how have people really driven fundamental change. How did the abolitionists end slavery and recognize rights of the freed slaves? How did the women's rights movement, which built up in the 1800s, how did they ultimately drive amendments to the US Constitution? That all built up from the grassroots. And we see the civil rights movement build up from the grassroots, and it involved lawmaking and using the law, going into courts. It involved using the law to reveal how the existing structure of law worked, why it was illegitimate and unjust, and why it needed to change and how it needed to change, and building the power up from the grassroots to drive change to the state level and ultimately to the federal level in the United States. So our communities are saying that their state government and their federal government isn't working, or certainly isn't working in their interests, and that has to change. But they can't walk into their state legislators today, and they can't walk into their US Congress today to ask for that change and think that they're going to get a positive answer. Instead, that's going to have to come up and build up from the grassroots, and it's going to have to be forced. Which is to say that, when we look back at these other movements, like the abolitionists, the US Congress was not leading the charge to end slavery. Our state legislators were not leading the charge to recognize the right of women to vote. They had to be forced in that direction, because that means we need cultural change and we need legal change to make that cultural shift binding. So that's what we see as absolutely needed. And so we're beginning to make change in the only place where communities can, which is at the grassroots in their local municipalities. We're beginning to now look at bringing communities together through what we've now beginning to form in a number of states like Pennsylvania and Ohio and Colorado, statewide community rights network, in which communities which have dealt with different kinds of starting issues, individual threats like fracking, like factory farming, like GMOs, are joining together because they understand that the common denominator is a structure of governance that doesn't allow them to decide what happens in their own communities. They're now coming together to drive change upward to the state level, to drive change into their state legislatures, and in some states which have citizens' initiative power, in which communities and people can come together to directly write laws and bring them to the ballot for a statewide vote, places like Colorado, where early this year in January, I think it was of 2014, we worked with our Colorado Community Rights Network to draft a statewide constitutional amendment to constitutionalize the right to local self-governance in Colorado and bring that to the statewide ballot, because they have citizens initiative in Colorado to amend the state constitution. So beginning to drive that kind of change from the local level to the state level, much like past people's movements have done. And to say, we've been in other countries, like we've been in Canada, we've done, democracy schools in Montreal and in Yukon, and we see a very similar conversation unfolding. We have to begin at the municipal level and join together to drive change up to our territorial level, our provincial level. We were in Australia, and I think it was the fall of 2013, in which a very similar conversation they're seeing, extraction of fossil fuels just increasing exponentially across that country. Many have described, we saw one author described Australia now as Asia's quarry, and that they see a very similar structure of law in place, a structure of governance, which is making extraction, a central piece of the economy, and that communities don't have the local authority to say no. Their state governments in Australia are legally authorizing corporations to frack, so when they look to their state agencies, just like in the United States, for help to protect them from shale gas drilling, they find out that their governments are actually legalizing that to come in, no matter the environmental consequences. So we're talking with folks in Australia about building a very similar organizing pathway to begin at the municipal level, then join communities together to drive change to the state level and ultimately the federal level. We see that building. We're working in the EU now with people that are seeing the need to build it up from the grassroots, whatever their starting issue is, whether it be fracking or water privatization or otherwise, that change has to build upwards, and it's not going to change until we can mobilize enough people and force that kind of change.
Yeah, we need an offense. For so many years, we haven't had an offense. We've been running defense, and our environmental activism is constantly on the defense. That's what it is, trying to keep things from getting worse. But we need an offense, and there hasn't been an offense in this country dealing with corporate power and corporate rights since the 1890s and the populist movement. But listen, if you ask the abolitionists or the people in the 1830s, what's the chance of Congress abolishing slavery? They would say the chances are less than zero. And this movement...
And beyond that, the U.S. Congress gagged itself from even having a discussion about abolition. They didn't want to even allow the debate to occur on the floor of the House or the Senate, because they understood by even having a conversation about ending slavery in the U.S. Congress would actually perhaps open up the idea that maybe we shouldn't be enslaving other people. So, they gagged themselves to prevent that kind of conversation. So to look to our Congress to end slavery was out of the question. It had to be forced there. And similarly, to look to the United States Congress to do something about climate change, that's not going to happen until it's forced.
And forced in a certain way. So the Ted Welds and the William Lloyd Garrisons and the abolitionist movement leaders, they didn't set out to create a slave protection agency.
Right.
They didn't seek to create a regulatory structure that sought to regulate how many lashes slaves could get on an individual basis. But that's pretty much where our environmental movement is stuck today, which is on the defensive, attempting to make the harms a little less worse, but not on the offense. And in fact, most of the institutional groups don't even think about going on the offense. They don't even know what that means. And so we need a plan. And the plan is a grassroots revolt, a community revolt that begins to redefine communities as not just the people who live there, but also nature and ecosystems within those communities. And then builds a structure of law that actually elevates those rights above the rights of corporations and commerce. It's pretty simple when you lay it out on paper. It's just the fact that most people believe they live in a system that they don't live in. And they believe that some of those things are already there. And our job in many ways over the past 10 years has been to prove that they're not there, that system of law doesn't exist, and it has to be created. And so it's about working from scratch.
What Marx used to call false consciousness, right? You think that this is all working for you, and it's not.
And we found that it really, maybe it's human nature, that it's not until a threat really comes into a community that where people can see clearly in stark relief how the structure of law works. You have to see it play out, and we had to see it play out. We had to experience it, and we had to wrestle within it to understand just how it worked, and then why did it work that way. And our communities have to go through essentially a similar learning process. And so I think people are coming to a place where they can take big leaps forward because things are becoming so blatant. And things are becoming so bad with the environment that people are able to take a leap forward to say, I understand how this is working. And we help them perhaps understand the history of how it got to where we are today, but they're able to say, this cannot continue, we refuse to accept this in our community, and they're beginning to take real action.
Yeah, and part of that is about picking fights. This is about picking fights. You don't change existing systems of law unless you pick fights with them. It's about confrontation. And so a lot of this is about communities putting into place systems of law that will be the systems of law in 60 or 70 years, but aren't yet. They're putting those in place, and then they're saying, come on in, we're ready for you now. We're ready for you now. We've written the script. This is the law. And now we're going to prove the difference between the existing system of law and what that new system of law needs to be. And it's that cognitive dissonance between the two, which is beginning to build a movement in the United States, at least, in some of these other places it's beginning, towards driving that new system of law into these higher levels. But it's that fight, it's that confrontation, it's that struggle. That's what produces eventually that new system of law.
You know, it helps in some ways when the government becomes more transparent about what it's trying to do. So for example, in Colorado, you have the Governor Hickenlooper, who has publicly stated that he's going to sue any community that tries to interfere or ban fracking. And he's made good on that promise. So bringing to bear the state government against its own communities to overturn their democratically enacted prohibitions on fracking. And so when your own governor is saying that he's going to sue his constituencies, his communities, the people who put him into office, when they're trying to protect themselves from something that's a very real threat, that makes things very clear to people. And I think it helps a lot of people to say, this isn't right, and we need to drive change. And that opens up a window of opportunity for people to say, we're going to drive that change, which is why in Colorado, people were ready to move forward with a constitutional amendment to say, we need to take these decision-making and put it into our own hands.
And certainly not in the governor's. That was successful, wasn't it, the Colorado initiative?
So the initiative was introduced, and then, like any initiative, it has to go through a state approval process before you can bring it to voters to collect their signatures, a petitioning process, and collect a certain number of signatures. I think it's 85,000 plus in Colorado to qualify it for the ballot. The oil and gas industry, not surprisingly, challenged that the initiative was even being proposed. They sued to keep it from ever reaching the ballot, let alone having people sign it. And so they were able to successfully delay it a number of months. That didn't give enough of a window of time for us to collect, or I should say the Colorado Community Rights Network, to collect enough signatures to qualify it for the November 2014 ballot. So they were able to delay it long enough. So what's happened is that the group is going to reintroduce it shortly so that they can qualify it for the November 2016 ballot. With an understanding the oil and gas industry will do everything they can to prevent it from moving forward, both from even collecting signatures to try to qualify it for the ballot, and then once it is qualified, they'll run a very intensive campaign to make sure that nobody votes for it. That's their goal, is to prevent any kind of blade of grass from growing.
But these folks in Colorado beat the oil and gas companies in the Colorado Supreme Court. So the Colorado Supreme Court issued a ruling essentially in favor of the Colorado Community Rights Network that this was a legitimate, valid initiative to be placed on the ballot, which is the hurdle that everybody goes through in Colorado when they try to put initiatives on the ballot. They ruled in favor of the Community Rights Network, and now it's been ballot qualified, ballot validated to move forward, which is a huge deal in Colorado, especially when we're dealing with an initiative that would, for the first time in the United States, return real power to the municipal communities to further legislate to support the rights of communities as well as the rights of nature within those communities.
So did you said November 14 or November 16?
They were initially looking, they introduced the initiative into the process, the state review process, which they did get through to qualify it for the November 2014 ballot. The oil and gas industry was able to delay it long enough to prevent that from happening. And so now the group is going to introduce, the next time they can bring it to the ballot is in November 2016. And so that's where they're aiming at now.
In Canada, the municipality is a creature of the province. I don't know if that's the case in the States as well.
Very much so.
So presumably the state is consistently saying, and the province would be consistently saying, this is beyond, this is ultra virus. You can't, this is beyond your powers, you can't do that if we say you can't. What happens then? I mean, in a sense, when you said return the power to the municipalities, they never had it in the first place, did they?
Correct.
Right?
Yes.
So,
yeah. And in some ways it's about returning the power to the people within those municipal communities. But as with Canada and the United States, you know, you open up any conventional law book, it says municipalities are creatures of the state, whose powers are wholly controlled by the state. So the state chooses to create, the state can abolish. If the state chooses to get rid of the city of Philadelphia tomorrow as a municipal corporation, the state of Pennsylvania, they could do so with the stroke of a pen. There's nothing constitutionally stopping them from doing that. It may not be the best political decision that people ever made, but there's nothing constitutional or legal that stops them from doing so. This work is about taking municipalities and the people within those municipalities out from under that structure. And in a lot of ways, that structure makes no sense. We had cities and municipalities before we had states. They predated states. And so to say that municipalities are merely creatures of the state just is plain wrong from a historical perspective. There were also, in the late 1800s, two battling theories of law in the United States. There was Judge Cooley from the Michigan Supreme Court, and there was Judge Dillon from the Iowa Supreme Court. Judge Cooley said people have a right to local self-government in their communities, which means that states can't abolish the municipality and that their municipal government has certain rights and powers that they could exercise against the state, so not a creature of the state. Dillon, on the other hand, said, of course municipalities are creatures of the state, and in fact it's not even necessary that people elect their representatives within their municipalities, because since they're just an administrative arm of the state could appoint the officials. There's no need to elect them because it's not a democratic entity. So both theories climbed up. Both had about 20 state court converts. So 20 states in one camp, 20 states in the other camp, went up to the U.S. Supreme Court, and the U.S. Supreme Court picked a winner. And the winner was Dillon. And Dillon's rule says that municipal corporations are merely creatures of the state. They only have the powers that the state gives them. And in fact, if they try to operate outside of those, that they automatically become ultra vires. The Cooley states kind of withered away and everybody adopted the Dillon rule. That's what happened in the United States. What's fascinating today is how the state mechanism responds when municipalities begin coloring outside the lines. So people in Pittsburgh, for example, who moved forward to adopt a law, first major municipality in the United States, to ban fracking within the community, and also stripped corporations of certain constitutional rights within the city of Pittsburgh, and also recognized that the rivers within the city have certain rights of their own as ecosystems within the city. That passed all of those things. Well, the first thing that happened was the Pennsylvania legislature passed a law that says, okay, if you pass something like that, you're going to have to go through the special scrutiny of a state agency, and we're going to give a state agency, not even the legislature, the power to overturn or nullify whatever's passed within the locality. And earlier than that, you had other municipalities in Pennsylvania that had passed factory farm laws saying, no, we're not going to allow corporate farming in our municipalities. In response, the state legislature stepped in and now puts the state attorney general's office at the control of the agribusiness corporations that are stopped from coming into those municipalities by virtue of the ordinances, to have the attorney general's office sue the municipalities in the name of the state. So no longer the corporation running around trying to sue these individual places, but now it's state taxpayer monies being used to fund the Attorney General's office to sue these municipal communities in the name of the state, not the corporation. But all the corporation does is pick up the phone and call the Attorney General's office, and they assign an assistant Attorney General to come in to sue the municipality. So the problem in many ways is not the corporation. You know, the corporation is what some communities run into first because they're proposing to put something in. But it's the structure of law, it's the governmental system that enables the corporation to do what it does within our communities. That is the problem. And it's a phrase that we use, which is the corporate state. We have a corporate state, whereas the state's role is to enable the corporation to do what it does within the communities. And so what we've developed in response to all that is a theory of law that people within these communities, within U.S. communities, have a right to local community self-government. And it's a constitutional right to local community self-government. And that right is violated by corporate rights that are used to try to overturn it, by preemptive rights when states attempt to set a ceiling so that they regulate fracking, and then a community under the current system of law can't ban it. Under this theory they could. And also under Dillon's rule to say that communities have a right to local community self-government. You can't be contingent upon a state authorizing a community to do something to actually exercise the lawmaking. So our job in many ways, as complex as it sounds, is to give birth to that right. Because once you birth that right, the other doctrines have to respect that right and change accordingly. So it's those doctrines in that box that have to be removed, and this is how communities are beginning to move to remove them.
And you asked the question of what happens when a community confronts that structure. And there's the substantive overrides that occur, which is, as in Pennsylvania, industry went into the state legislature to get them to pass laws saying that communities can't ban fracking or ban factory farming, so that sort of that issue-based kind of lawmaking that occurs. In addition, what happens is the procedures of law that are available to us also get shut down. So, for example, the first place that we developed a community Bill of Rights framework was in Spokane, Washington. And there's a citizens initiative process in Spokane. So communities can draft a law, then bring it to the voters to sign and qualify it for the ballot, and then it goes to a citywide ballot. That's happened now several times in the city of Spokane, but each time that it's happened, there's been a response by the city. So you have communities coming together within Spokane saying, we want to establish rights of the Spokane River. We want to establish rights of workers. We want to establish the rights of neighborhoods to make decisions about major development projects that are coming into their neighborhood. And you see that the city government itself coming out in opposition, not only verbally, but also beginning to change how that initiative process works to make it more difficult for people in the community to use their, what many call their direct democracy authority, to directly make laws. So instead of going through their municipal elected officials, being able to directly bring a question to the ballot, we see the city itself beginning to restrict what that looks like to make it more difficult to qualify an initiative to the ballot. We see that coming in other states as well, in which communities are moving forward with initiatives, and you see their own government coming to try to restrict their ability to do that. You also see pre-election challenges being brought by industry that don't want to see a community in Oregon, for example, bring a question to the voters about banning GMOs. And so you see ag interests coming forward to say, we don't even want that to be able to go forward. So if we think about what that means, and we step back from it and say, that means that corporations are able to direct what we actually get to vote on. And they're able to restrict our democratic powers. It's not only that they get to interfere with what agriculture policy looks like, they get to interfere with our own democratic processes within our communities. And we were recently in the Yukon Territory, where communities also have a binding referendum power in the municipal level, which is not used very frequently. And we've been talking with people about what it might look like if they were, for example, to choose to ban fracking and establish a right to sustainable energy and self-governance in their communities. And we were talking with a territorial legislator who told us that even though that process is used very, very infrequently, that binding referendum power, that even now the territory government is thinking about restricting that. And so even our ability to make law, whether or not we even choose to use them, are getting restricted even further. And so that's the response that comes from industry and higher levels of government to try to prevent people from being able to change what the structure of law and governance looks like.
And through the work we do, it means reviewing all of these state laws and federal laws that have been put in place to recognize certain powers that municipalities have. Is to our amazement that in Yukon, they have a territorial or a municipalities act for Yukon, which talks about the municipalities within Yukon. There's actually a provision in there that allows corporations to vote on initiatives that have been advanced by citizens. So if citizens put a ballot initiative onto the ballot, there's actually a line item that gives corporations a vote on the initiatives within the municipality. It's to our amazement, because we haven't seen anything like that before. In the U.S., people joke about it. Oh, well, if the corporations had a vote. Well, in the Yukon Territory, the corporations do vote. They have a line item guaranteeing them a right to vote on citizens' initiatives. So it's another way of trying to restrict initiative power.
That's kind of breathtaking. You mean, so, let's say General Foods or something. Did they get one vote, or did they get votes in proportion to their?
But proportionate votes may be coming down the road. I don't know. But you open the door, a corporation having a vote. If a corporation is a person, as in the United States, that leads logically to, hey, corporations should have involvement in elections as well. And so we've joked in the U.S. about it. Oh, well, if corporations had a vote. But here we tripped across a place that actually the corporation does have a vote in the electoral process, and people there didn't even know about that provision.
Well, corporations spending money are now considered to be exercising free speech in the States, right, as a result of the Citizens United?
Well, it's a result of a case called Bellotti back in the 1970s. Citizens United took it one step further and used it to knock down campaign finance laws in the United States to say if corporations have free speech rights, you can't have campaign finance laws that restrict how and how much corporations can spend in elections independently. And so the Supreme Court struck that down. But we have a long history of cases in the United States state of Vermont required labeling for BGH in dairy products, so the artificial bovine growth hormone that Europe has banned. Mm-hmm. And the Grocery Manufacturers Association brought suit against the state of Vermont, contending that the labeling requirement violated the corporation's right not to be compelled to speak under the First Amendment. So, corporations have free speech rights, but they also can't be compelled to speak under the First Amendment. The court ruled in their favor, and the labeling law was struck in Vermont. And so you have all these situations where there's been confrontations between the rights bases, and corporations as persons have those rights under the U.S. law and also under other systems of law.
Do you have the right not to speak?
Yes.
Do you?
Mm-hmm.
Okay.
Yeah.
Okay. I guess the Fifth Amendment, you can't be forced to incriminate yourself, but
Correct.
But you can not be forced to speak.
That's correct.
More broadly than that.
Yeah. And people sometimes say, well, corporations have the same rights as persons. Corporations are just accumulations of persons or just groups of persons. Well, the problem is when you get into that logic is that the more wealth you have, the more rights you have under this system of law. And so when you take the corporate rights, combine them with wealth, like a Walmart or a Monsanto or whatever, it gives them more rights than the people that are in the communities in which they're operating in. And so it's that combination of the two that weaponizes the corporate rights to some extent, is the wealth to be able to exercise them.
Yes, that's right. Now, what you're describing here, though, is a sort of a corporate governmental vice on communities and on individuals that is quite breathtaking. So how do you attack that? I mean, you guys are obviously agitating at the grassroots to change all of that. And it sounds to me as though the more successful you are, the more the avenues are being closed down and are likely to be closed down. How do you get around that?
Well, we think that there's a pre-movement phase. A lot of people like to say, well, there's a movement against corporate power in the United States. There really isn't. I mean, it's the beginning stuff right now. It's like a pre-movement stuff. But if you go into a room and, 95% of the American public, you go into a room and tell them they don't have a democracy, they think you're nuts. They think you're crazy. So there's no way to build a movement until you have enough people who understand the system that they're in. So you have to, the Richard Grossman, our predecessor of ours, used to say, fish are the last to discover water. And so people think that they live in a certain system. It actually has to be proved to them that they don't. And so part of our organizing is picking these very controlled confrontations, setting up controlled confrontations between communities and the corporations, so that when that lawmaking gets done and the two systems, almost like matter and antimatter, come into conflict, that people can actually see and learn from what's happening and understand how the system operates. The organizing is almost done under a faith that once the people understand that they operate under a corporate state, that it's not a democracy, that people will actually begin to put energy and resources into creating one. But until you get past that stage, you don't have a constituency that can actually begin to build a national movement towards change. And so we think that the ordinance making that communities are doing now, we have served as special counsel to over 500 communities over the last 10 years. 200 of those have begun and have passed and adopted local laws that put forward a new system of law that's in contravention to the existing one. That the more those are challenged, the more judges that say, of course, you don't have a right to local self-government, the more state attorneys generals who file briefs that say you don't have a right to local self-government, the more that's reinforced in some ways, the better, because people begin to understand the system under which they live. They won't listen to Tom Linzey or Mari Margil. They won't listen to a Sierra Club. They won't listen to a group. But once the system itself begins to explain it to them that they don't live under a system that recognizes their right to self-govern, then what we see is people beginning to come to grips with that fact, that there's like a mourning period, that, oh my God, something has passed here and we need to build something new. And that building of something new then begins to evidence itself in concrete ways, like the Colorado Constitutional Rights Amendment that folks in Colorado are beginning to run would override the courts. So if the courts in Colorado are saying, of course you don't have a right to self-government, you don't have a right to ban fracking, you don't have a right to do this, and you don't have those rights at the community level, then people begin to override the courts with those constitutional amendments, and eventually to begin to change the federal constitution to override all the courts and all the legislatures. But that's an arc that has to build, and it can only build if enough people understand the system in which they live. And right now, very few people understand the system in which they live because it's all been camouflaged. They only see it when they hit it, and they only hit it when they want something different than what's being delivered to them by the system. And so we operate in that convergence zone, that confrontation zone, where we talk with communities to say, it's not about getting what you can get under the existing system. It's about getting what you want and what you need. And with climate change and species extinction and deforestation, all these other problems on the table, people are beginning to see the difference between what can you get under the existing system versus what do we want and need. We actually help them to build law based on what they want and need. And so it's that cognitive dissonance between the two which is beginning to build the energy and space for a movement to arise. And that movement's going to be something that we haven't seen in the United States for the past 100 years, 150 years, possibly back to the American Revolution, which is about taking wholesale the system of law that we have, which is an archaic system in many ways, and tossing it to the side, and then building a whole new system of government in its place. And that's a huge task, but that's, to us, that's the only fight we're fighting right now.
Boy, that's a phrase I want to linger on for a moment. The only fight worth fighting at this point. So once you've got the constitutional amendment, let's say sticking with Colorado, once that constitutional amendment is in place, in a sense, the courts cannot rule in favor of the corporations over the communities, right?
Well, they can always try to find a way.
Yes,
and so
I don't mean that this is easy, but that's the essence of the matter, isn't it? That it's taken beyond it's no longer at the discretion of even of the court system.
Yes, and there will be periods of time where there's courts that try to say something means something that it doesn't. You can't rely on the text. In other words, once that constitutional amendment was written, it's more than just ink on a page. It's actually backed by people and communities who have blueprinted it into a certain vehicle. And so the magic is not the ink on the page, the magic is not the constitutional amendment going into place, because it takes eternal vigilance after that. And in fact, we think it probably takes another round of constitutional change after that. So what's happening in Colorado right now is what I would call a liberation amendment, which is to say, okay, these places that are making these ordinances and these laws at the local level, we now need to seize the state to legalize them, to say these are okay, these are you're now okay to make more of these, and to enforce them. That's what the state amendment level is about now. But eventually, you need 300 communities, 400, 500 communities in the state who then begin to drive those bills of rights, the community bills of rights, up to actually embed those in the state constitutions as well. So the state constitution says, okay, people have a right to a sustainable energy future, and ecosystems have certain rights to exist and flourish within the state. So there's a procedural amendment, and then I think there's a substantive amendment that then runs as well. But it's going to be a constant, talk about a cauldron of bubbling matter. It's, you need a movement of constant confrontations between the corporations and the communities that then produce people who begin to move up to the state level and eventually the federal level. But it's all got to be cooking, and it's going to take 30, 40 years probably for much of this to go. And of course, things can move faster than that, as we saw with the Berlin Wall and everything else, that there's a perfect storm sometimes that happens. But it has to happen, and if people had been doing this 30 years ago, we'd be in a much better position than we are now. But having said that, we have to do it. And
I will say that what's happened in Colorado, even though they've only managed to get through getting the approval by the state Supreme Court that they can actually circulate the initiative for collection of signatures for then to qualify it to the ballot, even that they've only just introduced this initiative, that you now have other states that are looking to Colorado, essentially seeing it as a model for, oh, now we begin to understand why we need to be looking at actually, instead of trying to regulate shale gas drilling better, which communities learn that even when you better regulate shale gas drilling, you're still getting fracked. It's not enough for us to try to regulate bad things a little bit better. That still leads to ecosystem destruction. It may delay it a little bit, but it still means we're getting fracked and we're getting factory farmed and so on. Communities are beginning to see the reframing that this isn't just, we don't have a fracking problem, we have a democracy problem. We don't have a factory farm problem, we have a democracy problem. And that's why people in Colorado who are concerned about different things have come together to, we need to actually establish our right to democracy, our right to self-governance in our own state constitution so we can make decisions at the local level. That's reframing. It's creating a discourse in the state of Colorado that's spreading outside of Colorado as well, which is why our state community rights networks in places like New Hampshire, where they're facing unsustainable energy development and water privatization and other threats, they're beginning to take that language of Colorado and say, what would that look like here in New Hampshire? Because we have the same problem. Our issues may be a bit different, but we have the same structure of law and governance that's preventing us from deciding what happens in our own communities. And we understand it's not enough for us just to try to make change at the local level. We must join forces to drive that change upward and establish our right to local self-governance within the New Hampshire Constitution and with the Pennsylvania Constitution and so on. And so it's taking the energy that's come out of Colorado, which has been so important, and actually seeing what it looks like in other states as well. What people in Colorado have done is essentially revealed the structure for what it is, which is anti-democratic and anti-local self-governance. And now people in other states are saying it's helping them to see too the kind of change that's needed. It's the pathway that's being drawn for us. And I think that's been very, very important. And some people say, well, what's the point? You never got it on the ballot. You never even, got a chance to sign it and qualify it there, let alone lose at the ballot when the oil and gas industry mounts a no campaign. What's important is that people can begin to see the kind of change that's needed, and that creates the cultural change that is going to drive ultimately the legal change.
And we sometimes get two types of pushback. One is people saying, well, we don't want to have to deal with the corporate rights stuff or the preemption stuff. It's all Greek to us. We just want to ban fracking. Right. To which we say, well, you can go ahead and pass a 1-paragraph ordinance that says we ban fracking here, but that sucker is going to get struck down, quicker than a judge can sign the order striking it, because it goes against all of these other doctrines. You got to deal with the doctrines. You have to go after those doctrines. There's the structural stuff that actually has put into place your inability to say no at the local level, and so. We have a lot of environmental groups who are running around saying, oh, ban fracking here, but they're not getting into the structural stuff. And to us, that's a disservice, because what happens is people mobilize, they pass the fracking ban, they go into courts, the courts strike it down, then everybody goes home. And they say, oh, I guess we can't. And then they begin doing all the stuff around the other sides. And the other pushback we get is, what's the point? What's the point of passing this thing that nullifies corporate rights and preemption and the Dillon's rule stuff and recognizes the right to local self-government if you're just going to go into the courts, and the courts are probably equally likely or slightly less likely to strike it down on the same grounds, which is the U.S. Supreme Court has said corporations are persons. You can't say that they're not persons in the municipality. To which we say, well, that's what civil disobedience is all about. Civil disobedience is about recognizing unjust laws and calling them out. Our work is just more structured than laying down in front of the bulldozers, but it's the same thing. It's the community saying, we don't want it here, and we're going to seize our municipal structure of law to stop it, and we're going to do these things. It's almost like saying to the 4 African-American kids that sat down at the lunch counters at Woolworths, what's the point? You're going to go in and sit down, you're going to get arrested. They're going to come and arrest you, and nothing's going to change. Well, the kids that sat down at the lunch counter said to themselves, number one, it's the moral and ethical thing to do. The earth is being destroyed, so let's talk about morals and ethics and about how our activism has to line up with that. But second of all, they thought if they did it, somebody else would do it. And if somebody else did it, there'd be 10 more, and then 100 more. And it turns out within 3 weeks, there were 200 sit-ins. But nobody knew. Nobody knew when it was going to start. Nobody knew how it was going to start. But these kids said, okay, we're going to do it. And everybody opposed them. The elder reverend church community said, it's too soon, it's too fast, it's too radical.
We hear that all the time.
Yeah.
We hear that all the time. And I think to your point, it's one of the things I think that we as activists need to become much better at is recognizing this as very much long-term generational kind of change. You look at the suffragettes, it took 80 years in the United States to actually recognize the right of women to vote. The abolitionist movement took generations to end slavery. This is definitely going to be a long-term movement, and it's going to have some, 2 steps forward, 1 step back kind of thing. And I think we as activists have to get out of the mode of just trying to get, any number of Facebook hits or that headline tomorrow or 80 tweets, whatever it might be, that we have this immediacy in our culture. It's not just in our activism, it's our culture of immediacy, that we want instant gratification. That's not how real movements grow. They grow over time, and they recognize that they're long-term and that we're going to have fits and starts. but that it's all about making a significant cultural shift that will allow a significant legal shift. It took us a long time to get where we are today. It's going to take us some time to get out of it as well.
I'm struck by the fact that I think those who are not directly involved with the law often think of it as a kind of a cut and dried thing, and you go into court and there's this, I'm suing for that, you're resisting, or vice versa, and we come out to a decision and that's it, and everybody goes home and whatever we were fighting about is resolved and so on. But it's quite obvious that Tony Aposa says the law is a way of telling stories, which is a kind of a wonderful concept. He says it's a way of telling stories where there's a record, and there's, and people have to somehow come to terms with it, and even if you lose, the story's still been told, it's still out there. A lot of what you're doing has the same sort of character, right? It's education, it's consciousness raising. You're not expecting to win big in the short term, but you keep chipping away at it, and you keep growing the circle, as you said about the kids at the sit-in. That's kind of the perspective it has to be, isn't it?
Yeah, and in some ways the work that's happening along these lines is having a side effect of beginning to influence some conventional court decisions. So, in late or earlier this year, earlier 2014, we had a court in Western Pennsylvania rule that corporations were not persons for purposes of certain sections of the Pennsylvania Constitution. That hasn't happened in forever. And she wrote a 20-page opinion going back to 1776 and looking at the intent of some of the drafters and holding that corporations were not entitled to certain state constitutional rights. That was groundbreaking in itself. And then we had this decision dealing with the state legislature coming in to tell communities that they couldn't do anything about fracking or oil and gas extraction. Some municipal communities stood up, sued the state. And the Pennsylvania Supreme Court came out with a decision that said municipalities have duties that are independent of the state, which is something we haven't seen in 100 years in courts. So here's the highest court in Pennsylvania saying that there are some municipal powers that the state can't tinker with, that the state can't change, state can't abolish, that the municipality has separate duties, and that's something that's completely foreign to the U.S. legal structure as well. And what's also funny is in both of those cases, the lawyers didn't even really brief those issues because they were such a long shot that the issues weren't even briefed. These were judges stepping in, picking up one fragment, one small thing within those briefs, and picking it out, making that the decisions. And I think that's a lesson for the lawyers, that we need to begin to be more confrontational in the briefing. We need to begin to reach, not just doing the established law and arguing from that, but also reaching to bring the new stuff in.
And when we think about private corporations, they don't see the law as static. In fact, they're constantly changing the law. Citizens United, decided in 2010, they were able to overthrow what was existing law. And they said that existing law, which restricted how much they could give and how they could give monies into elections, that to them was a barrier. And it was a barrier that they, instead of trying to work around, they just smashed right through. And so they have that mode that they can change law because they do it constantly. They're constantly going into court to change law, as well as into our legislatures in the US Congress. We have a tendency to see law as something static, that's immovable. And if we continue to hold that, we're not going to be making the kind of change that we need to. We need to adopt a very, I think, proactive, offensive strategy, which means we have to be able to change law. And we're beginning to do that in communities where they're saying, we understand right now we don't have the power to change law at our legislative level or congressional level. We're going to do it right here at home and begin to force that outward.
Yeah, and we have so much pressure, even as kids, all the way up, saying the thing you do with the law is obey it. Right? And that's, the idea that law is malleable is, that's in itself a foreign concept, I think, for probably most citizens. Right?
Yeah, we have to do a lot of myth busting in our work. Myth busting about the United States Constitution is the most democratic instrument, that this mythology about the Constitution that in our democracy schools we talk a lot about, is what that mythology looks like, why people thought it was such a democratic document, and that we have the best democracy in the world, perhaps the only one, many people believe. And the abolitionists looked at the Constitution, saw it as a slave document because it codified slavery. Women looked at the Constitution and saw nothing there. They weren't even recognized within the Constitution as having rights, let alone to vote or to own property or divorce their husbands, whatever it might be. There was nothing in there for women. In fact, William Lloyd Garrison, who Thomas mentioned, one of the leading abolitionists, he used to burn the Constitution at rallies during the abolitionist movement because he said, this is a slave document. And he would look to other things like the Declaration of Independence, which said all men are created equal, and plant his feet there, not in the U.S. Constitution. The Constitution, he understood, needed to be gotten rid of. And that was, of course, blasphemous to say, and it continues to be blasphemous to say.
This is heresy.
That's where this is heading.
Yeah. But, and if you listen closely, you can still hear some tremors. You can hear the tremors of what's coming. In mid-September of this year, in Colorado, a curriculum board for the state said that they needed to rewrite the history textbooks to eliminate civil disobedience from the textbooks, to actually put in, to stress obedience to the law. That's how the curriculum board said it. 1,000 high school students walked out in protest of the curriculum changes. And, you know, that's pretty abstract. It would be pretty abstract to some people. You know, we're talking about textbook changes and those types of things. There's 1,000 students, 1,000 high school students walked out in protest of that. And so there's something still there in our collective memory. It's very small and it's been pushed to the back, but there's something still there. And this work is about triggering that.
When it emerges, it has some of the energy of a jilted lover, right? Or of a betrayed lover. You know, here I have thought I was living in a democratic country. Now I find I'm not. I'm good and mad.
Yes.
Right?
Yeah, you know, I think that's very true. When we meet with communities, and particularly in democracy schools, which are really intensive, you know, 10, 12 hours in a community where people coming together to really examine how does the structure of law work, why does it work this way, and how are other communities beginning to change it. You know, people can end up in tears because they're discovering that their country isn't what they thought it was, and it does feel like a betrayal. Other people in other countries often say to us when, you know, we talk to them, when we visit with them and talk about what they're trying to do and share our organizing model and why we do what we do, and they look at the United States, and for them it's very clear about how the United States works. In fact, because the United States doesn't just betray its own citizens, it's also going outward into the outside world and doing similar things, and our corporations are going into other countries and stripping them of their environmental protections and so forth. So in some places it's easier to see it than here, perhaps in the United States, where it is very well camouflaged, but more and more people are being able to see it clearly as the structures of government are coming down on them and telling them very, very blatantly that they don't have the power to protect themselves.
And there are some funny moments. I mean, we've done democracy schools in some indigenous communities and First Nations communities. And we'll have some you know, white people, Caucasians, sit in with the indigenous people, and the school will be for us. And in one of the schools, we had the Caucasian folks from the municipalities. They were having real trouble with all of this. You know, oh my God, we actually live under that structure, and this mourning period type of thing where people get pissed off and it's sad and all those things. And so they were going through this fuss and trying to answer them. And then the indigenous person who's their tribal member was in the school, and she basically stood up and said, you know, wow, that's, you know, really bad that the white people, you know, they don't even know the system of law they work under. She goes, at least we know we live on a reservation. At least we know that. You don't even know what you live under or what you live in. But in some ways, it's the same thing. You know, we're not free. And it always sounds strange to sometimes say that, but we're not a free people. I mean, you're not a free people when you're harnessed to fracking, whether you want it or not, or resource extraction, or forced pooling, which is now these laws that even if you don't sign a lease, the fracking and extraction companies can come in and take your resource from under your land, even if you don't sign a lease. They can force you into those agreements. Those are not the laws of a free people. And until we start talking about freedom and liberty and those types of things in this context, then we're always going to be subject to that kind of control. We are not free in our communities. Our communities are not free communities. They are enslaved in many ways, and they're enslaved to that process. And until we're able to dismantle that structure of law that's over top of them, we're always going to be in that position.
Tell me about a democracy school. If I go to a democracy school, what am I going to see? Or if you, if you guys bring one to my community and I go, what will I experience?
Well, first we'll hand you a 350-page curriculum. And of course there's a pop quiz.
And now that the first 40% have left the room.
You know, we struggle in the democracy school because you have to draw some sort of balance. You know, we begin by talking about how does the existing structure of law work today? And generally we talk about it within the environmental context, so that a community, what happens when a community is facing a factory farm? And we take a look at how does that structure work, not only the legal side of it, but the cultural side of it. So for example, with factory farming, which is, you can have a factory farm come in, which means that you can have 10,000, 20,000 hogs warehoused in a setting, and it produces all sorts of problems, not only just for the hogs themselves, who are in very unpleasant conditions, but also tremendous amounts of manure. And what do you do with all that manure? And what do you do about the air quality and the water quality and all of the impacts that come with a factory farm? Not to mention the fact that it throws independent and small farmers, family farmers, out of business. I mean, we've lost hundreds of thousands of farms and farmers over the last 30 years because of this industrialization, this corporatization of agriculture. So we talk about that in the democracy school, not because we want to learn the particulars necessarily about factory farming, but just to use it as an illustration of how does the structure of law work. So a community facing a factory farm, what do? They call out their state agency, say, hey, we understand that this is going to have a wide range of impacts on our environmental quality, on our local economy, on local farmers, and our ability to define what sustainable agriculture looks like. And their state government tells them that they don't have the power. Or actually, I shouldn't say that. The state government doesn't tell them they don't have the power to decide about a factory farm. They say that if you want to get involved, you can look at, we've got a permitting process to permit a corporation to come in and site a factory farm. And they get people involved in that permitting process. But under that permitting process, which we examine in the democracy school, communities can't say no. They can't say no to a factory farm because the state government is authorizing, literally permitting a corporation to come in and site that factory farm or that fracking or that mining. So in the democracy school, we reveal what that structure looks like. And so that everybody sort of gains a similar understanding of how does the structure of law work? And then the question is, well, how did we get here? And that's where we have to sort of define a bit of a balance of how much history do we go into? Because there's a lot of history. How did we end up with the American Revolution, our first major rights movement in this country? We stood up to the existing structure of governance in England, the king and the parliament, to say we refuse to accept this any longer. It took a war, but we broke away from England and defined our own country. That was our first major civil disobedience movement, you could say, in the United States. So how did we get to that place? And what were the forces that actually brought along? And we got to see that it was continued action like the Stamp Acts and other acts that interfered with the ability of the people in the colonies to self-govern. They wiped out the colonial legislature so that people couldn't actually decide what happened in their communities and so on. And so we saw those forces of England coming against the people in the colonies, which ultimately led to revolution. We look at those past movements to learn the best lessons out of them. How did they actually make the change that they were seeking? And what did it take, not only in terms of time, but the kind of actions? And so much of what we look to in our own organizing today is those acts of civil disobedience, the use of the law itself, beginning at the local level and driving it upward. The suffragists, for example, which we look at in the democracy schools, they drove 400 different referendums forward to try to recognize the right of women to vote. And they did that over a huge stretch of time to ultimately change the US Constitution. We look at how the structure of law works today. Why does it work that way? How did that history end us in this point today where we can't say no and protect ourselves in our own communities? And then the juicy stuff, what are communities doing now? What does that change look like in our communities today? So we break it apart. It's a deep examination. It's very intensive. It can feel like a betrayal once we start looking at, we go through the Constitution and the curriculum and say, wow, it codified slavery. People don't know that. People don't realize that, for example, we talk about the US Supreme Court a lot, and we don't realize that in our US Constitution, the Supreme Court could be made up of one person. One person could have that power to make those kinds of decisions. We don't know that. We don't realize that our president is indirectly elected, that the US Senate used to be indirectly elected, appointed by others instead of we the people, that we didn't even have the chance to vote for the US Senate, which we don't even vote for our president today. That's indirectly. So we have so much that we have to reveal in the democracy school to say, people walk out saying, I didn't realize my structure of law worked this way. I didn't realize the government worked that way. And then the question is, it's really a launching pad for communities to say, we understand now, if they want to move in this direction, that we're talking about systemic structural change. It's not enough for us just try to do a single issue ban on fracking, for example. We actually have to take on the system of law itself if we're able to protect that ban on fracking, because what's needed is systemic change. So the democracy schools are really intense. They take a lot out of people, I think. And then the question is, do they want to move in a different direction with their own activism?
And the linkages that we find in the democracy school to other countries. So the English common law system, because we started out as an English colony. And our early colonies were corporations that had English common law that controlled them, and then the early state legislatures, the English common law stuff came in. That's our link to Australia and to Canada, because they all have similar legal systems, all based on that English common law system, including Nepal and to England, yes.
Yeah.
And to some extent to Ireland and the work we've done in Northern Ireland as well as Ireland. But so there's a common linkage there. So it's not like starting the language from scratch when we go into these other places. We find the commonalities. So in Canada, for example, where we were recently, about 80% of the law is the same in terms of corporate rights stuff. Slightly better in Canada, because Canada doesn't have a commerce clause. In the US, we have a commerce clause which corporations use to actually stop communities from interfering, quote, interfering with interstate commerce. So since oil and gas extraction is interstate commerce, that sometimes that's used by the corporations as a corporate power to strike down municipal laws. Canada doesn't have that, but at the same time, Canada has been adopting some of the US jurisprudence on commerce into other parts of their law. And so everything bleeds over. And so there's that kind of sharing between those English systems of law as well. So in some places it's slightly better, in other places it's slightly worse.
But it's not fundamentally different. No. So now let me say that I've been in a community, we've been confronting a hog farm or something like that. We've come to you, we've had these discussions, you run a democracy school, I come out of the democracy school, what happens now?
If a community chooses to move forward, and the democracy schools are hosted by communities, which means we don't target communities to work in. Right. They contact us, we begin to have a conversation, and if they want to move forward to the democracy school, we hold a democracy school. Often what happens after a school is that a core group of folks who come out, graduates of the school, and come together and say, we want to move this, we often call it rights-based organizing, forward in our own community. What the Community Environmental Legal Defense Fund will do is work with them on that process, which means helping them to draft a local community bill of rights for the municipality, help them to navigate what that structure of lawmaking looks like, whether they have to go through their municipal board of supervisors, do they have direct democracy, as some call it, for the citizens initiative process, help them to understand what that process looks like. Help them to educate their own friends and neighbors and family members within the community. Because just like they went through a very intensive democracy school, in some ways you have to do that within your own community so people understand why are we going through this? Why are we addressing corporate rights, for example, when all we want to do is stop fracking here? That systemic change, the need for that change, that has to be a community-wide education effort. And so we help folks move along that pathway, beginning with educating themselves, then educating a broader swath of the community, help them to draft a local law, and then people begin to move into campaign mode in which they develop their campaigns through their municipal elected official, that body, or through their initiative process, and they move in that direction. And so the Legal Defense Fund, we have both public interest law side of our organization, and largely we're grassroots organizers working directly with communities to help them make this shift.
I want to move just also to touch on the use of film, because it seems to me that your involvement with Democracy 2.0 basically sounds like that's another major tool for the toolkit that you would be using, perhaps in the democracy school, but more broadly too. Is that?
Yeah, We the People 2.0. Mm-hmm. Yeah, we've been working with some filmmakers at Tree Media for the past couple of years to essentially take the story of this organizing, how and why it's evolved, stories from communities. I know they spent some time in Pennsylvania talking particularly with communities there where our work first began, to talk about why are communities on this journey. And essentially all that we've been talking about with you, how communities are going through their own, essentially it's a very similar journey as they've tried to stop fracking or factory farming and what have you. And the film is really to share that story and reveal how people are moving in a very different direction in their activism. We do think it will be very powerful to be able to share that. And we've talked about taking snippets of it to show in democracy school and at public talks and public forums, and that communities themselves can watch the film and other films like this one, and really hold a discourse in their community dialogue. That's a very different kind of dialogue than just talking and learning about, well, what are all the problems with fracking? How many parts per million of XYZ chemical or toxin do we have in our water? It's taking ourselves out of that discussion to talk about our right to stop fracking or whatever it might be altogether. It moves it from getting ourselves so deeply involved in the environmental regulatory processes and understanding, all of the particulars about what happens when we frack, to people really wrestling with this idea of democracy and what does it look like to change their own community.
One of the problems is this work is so different that the media is only helpful if it actually gets people to do a different kind of organizing. And unfortunately, most of the one-off media, like the articles that we get in the newspapers, the national press, they don't do that. They actually tell the story in a conventional way, and then people don't understand what it means. And so you get a bounce off from it. And so it's not really worthwhile in some ways because it publicizes the work, which is good, and people find us, which is good, but it rarely ever leads to actual communities, new communities going through this kind of organizing process. Most of the work we do is all up here. It's about people coming to grips with what system they live in and then coming to grips with what new activism is needed. And that's one-on-one stuff. It doesn't come from media pieces or Twitter or Facebook stuff or whatever. It comes from the more engaged stuff. And so we tend not to focus too much on media. That's the one-off variety. It's always good to get a piece in the New York Times or the LA Times. That's great. But it doesn't necessarily lead to more organizing. And in fact, it draws a bullseye on some of the communities that we're working with because then the corporate boys know what's happening in those communities. And so it's a double-edged sword for us in many ways. But the more intensive stuff that can help people understand why they need to move in a different direction and then for them to begin to do a different kind of activism, I think is very valuable.
So my thought about the film was that presumably you're getting a lot of calls from people all over the country, and not necessarily all communities, but an individual here and a small group there, and maybe you get to the point where you're looking at municipalities in some of these cases later on, but maybe not. But something that tells people what the hell this is all about, like a film, for example, would seem to be a very useful thing. I call you up when I'm an isolated individual in some corner of the country, and you say, well, there's a few things you can do. Here's some books you can read. Here's a film you can watch.
Yep.
Maybe just a nice way to fan the flame a bit.
Yeah, we do. We continue to develop those tools, and I think film can be really valuable in that sense. And people can watch it, on their own computer or whatever it might be. And so it's an easy way for people to engage. We have, PowerPoints, and we had a book that Thomas co-authored called Be the Change, which shares these stories. But what we have found, the most important piece of our work is the one-on-one interaction with people in a community. That is the absolute most valuable thing, which is why our staff is largely made up of community organizers who spend all of their time in communities. This is very much, we think, talking about past movements, they had circuit riders, people who would go out into the countryside and give lectures and stay overnight and go into the next community and so on. We think the most important work gets done in person, which is, it's difficult to do, it's very time consuming, and it's very resource and time intensive. We think the films are it's a way for people to begin to engage in the conversation, then ultimately we need to have those direct conversations with people. We think that's the primary way people truly engage.
It's very rare for someone to pick up the book, Be the Change, and then all of a sudden move into being an activist on the basis of the principles of this organizing. And one of the reasons why it's so difficult to move in that direction is because it's so easy to stop the organizing from happening. So somebody picks up the book or sees the movie or whatever and says, hey, I want to do this. And they go to their elected official and they say, hey, Jerry, we need to move one of these ordinances here. And Jerry says, well, that's crazy. We can't do that because we're a municipality and we're a creature of the state and we don't have the power to do that. You need to go talk to your congressman or to your state legislature. And then that stops the person because they say, oh, he's right. We are a creature of the state. And there's nobody engaging him to override that concept or for the brain to come to grips with it. Or Jerry will say, hey, that's a really good idea. I'd like to do that with you. And then he turns to the municipal lawyer and says to the municipal lawyer, hey, we want to do something like this. The municipal lawyer says, you can't do that. That's unconstitutional. That's illegal, right? And the base is not there yet for the individual activists to then go to the lawyer and say, well, let me talk to you about that. Let me discuss that with you about whether that's right. And generally that concept never enters the lawyer's brain about whether it's right or not. It's just the law, right? And then the activists, how do we go to the city council to override the lawyer? That takes a lot. The lawyer says you can't do it, you're going to get sued. The elected officials have to say, we don't care. That's part of it. We need to stand up for what we need, and we're not getting what we need, and they have to override the lawyer. So how does all that stuff happen? Well, it happens by confident, self-confident, aggressive people. And you don't get that from reading a book or picking up a newspaper article. It doesn't give you what you need to become that person in the community who then drives something within that municipality. And so that constant engagement by our community organizers, or, here's a book that deepens your understanding on how the abolitionists did it, or here's a book on the populists, or, let's have an hour phone call with the core group and talk about what challenges you're going to meet. We can predict them at this point. We've been doing the work for so long. You're going to hit this first, you're going to hit this second, you're going to hit this third. How do you get ready for it? And not only get ready for it, but understand it's predictable. And when the lawsuit comes on the door, here's how the lawsuit will be drafted, because it's boilerplate. It's X, you can't do it. 2, it's unconstitutional, it's illegal. We have expert lawyers now who are working in a legal network in the United States who have seen all of that before. They know it. It's not an emergency situation. It's not, oh my God, head for the carpets and hide yourself because we're scared of all this and terrified. It's terrifying. It is. It's terrifying and horrifying. But we know what it looks like now. We understand its shape that it takes. And here's how you respond to it. And here are the strategies for doing that. We know that stuff. But if you're not working with us, in a very close capacity, it's very, very difficult to do it at home alone. The joke is you can't do it at home alone. You got to do it with other people. And it may be other communities next to you that are doing it, which is something that's worked, or directly with us, but one way or the other, it's a way of being. It's almost more than just, here's the tools. It's about how do we understand and how are we capable of constructing it ourselves, kind of thing.
We take both hope and lessons from other movements. These other movements, like the abolitionists, you had Ted Weld, who was became a leading abolitionist, and he was a circuit rider. He went out and met with people in different communities and different towns and so on to talk about the need to end slavery, and he was by himself. Talk about isolating. He traveled on his own, and for a long time he was on his own, giving these kinds of lectures and having these kinds of conversations, and ultimately he trained, 12 people to essentially to replicate himself, so that they were able to hold these kinds of conversations in communities, and then they replicated themselves, basically training other people to be able to have these kinds of conversations. For a long time, the women's rights movements, you had Susan B. Anthony and Lucy Stone and Elizabeth Cady Stanton, and they would go out into the world and have these conversations, and they were by themselves. It starts very, very small. And so one of our challenges, and one of the things that becomes so important in this work, because it's so people-to-people oriented, that's how we see it moving, is training other people to have these conversations, which are so difficult and so complex, but training them, deepening their understanding, having them be able to effectively share the story of why did they even get off their couch to do this work at all, and why it has really become for them it becomes very much not only just a passion, but a way of life in some ways, because they see how much needs to change. And sort of building the body of people, the universe of people who are not only willing to have the conversation, but are willing to take it to others. That's what past movements have shown us has become so important and so effective. And I guess I draw the hope from, they start, Ted Weld, one person going out into the world to talk about ending slavery, that meant changing the Constitution. That's a really important lesson for us, and one to take to heart, to say it can start with one person, and you have to be able to broaden it out to many, 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 many more. And that's where I think we are at the very beginning, just like they were at the very beginning of making that kind of change. I think we're at the beginning, but it's beginning to spread as more and more people say that they want to participate in it, and not only participate in their own communities, but take it into other communities and begin to take it to the state level and beyond.
The other thing that occurs to me is that you're rowing upstream in terms of the fragmentation of attention. This is not something that you can do on Facebook and Twitter, right? This is, and we have, a friend of mine says that there's research now that shows that the average attention span of a first-year university student is 5 minutes.
I'm surprised it's that long.
Yeah. So this is in a sense, this is old-fashioned, as you say, brain work. This is stuff that you really have to pay attention to. That's got to be rowing upstream in terms of the kind of environment we find ourselves in. Right?
Yeah, I think that's a really key challenge. And one of the ways that we help people overcome that challenge, that fragmentation, not only of our attention spans, but on our issues, because particularly as environmental activists, Jane Ann Morris has written a lot about this, and we use one of her pieces in the Democracy School called "Help, I've Been Colonized and I Can't Get Up." She talks about how we, within the environmental movement, we fracture ourselves. We don't even, ask other people to do it for us. We fracture ourselves by, I think she says, by one species, one tree, one toxin. So we're all working on this particular toxin today, and then, then we have people who are working on this tree and that stand of trees and what have you. Anyway, the point is that we fracture ourselves pretty readily, and we fail to see the common denominator that connects us all, which is that we don't actually have the power to protect that stand of trees, and we don't have the power to stop that toxin from being dumped into a frac well. We simply don't have it. The structure of law is set up to make sure we don't. We fail to see that connection. One of the challenges we have is overcoming that failure, to help people to see that it's common. We face a common barrier, and those barriers are made up of these legal doctrines which stick us in a box, which we need to break out of. Once we're able to overcome that, it helps to not only provide people a very clear picture of how the structure of law works today, but it also gets them to a place, I think, where they understand not only in their own community, but able to see across into other communities and even into other states to say, we understand that we all share the same common problem and that it's systemic change that's needed. I think it helps to helps to reframe the problem from just being about fracking, for example, to being about something bigger. And that, I think, helps to broaden people's way of thinking about it. And that means that their attention span, I think, becomes broader and longer, and their willingness to engage becomes deeper, because it becomes a deeper problem. It's not just about the problem we face today. It's about the problem that we're facing throughout our lives.
I think generally we have also two constituencies coming in the door. One is first-time activists, so people living in a community who's never done this work before, whose attention span is longer than 5 minutes because it has to be. They have to understand the stuff because they've looked at the other options, and none of them are actually going to stop what they want to stop in the community. And so when they come to us, it's a different dynamic. We become relevant. We need you, and we're willing to listen, and we want to figure out if we can use what's happening in these other communities in our own community. So I think that window is based on self-interest, which is we need what you can provide, and so our attention span is longer than 5 minutes. And the other constituency is refugees from the existing environmental, progressive, liberal organizations. So every once in a while, we'll get someone who's heard of us, who's worked for 20 years in the regulatory environmental system, who has burned out in that system and understands that it's intended to burn you out, that it's its intent. And those people will come straggling in the door every once in a while. And when they come in, you have a person whose attention span isn't 5 minutes, who has a wealth of information with them, who can serve as a testimonial to the existing system not working. They come with a treasure trove of different skills and resources and assets. And we put them on our board or our board of advisors. We actually try to integrate them into the work. But those folks we call them the refugees coming out of the existing stuff, who have tried to make the system work. And many would argue, I would argue, that the system would be worse now without them on the front lines who have actually tried to make the system work. But now they're coming to a self-realization, like we did after 10 years of doing conventional, traditional environmental law, that the system has nothing to do with environmental protection. It has to do with something different, which is about legalizing harms. That's what the permit system is about. And so when those folks come in the door, they're a big boon because they bring with them those constituencies and information and resources and skills and things that the new activists don't have. And so we hope to join those two together in different places to make the stuff move and tick. But that's how we get around the 5 minute, attention span issue.
That's quite fascinating, and I think I think I'm not sure if the phrase was legalized harm, but the existing system is there to legalize harm. Maybe you can mitigate it a little bit, but essentially it's there to that is really a very key insight, isn't it?
Yeah. If you want to dump mercury into a stream and you don't have a permit to do so, it's an illegal activity. You can't. Mm-hmm. But if you have a permit, it legalizes it. So you can put certain parts per million of mercury into the stream. You can emit that. I mean, they're not called permits for nothing. They permit a certain activity to occur. And even when there's a problem or a confrontation, It's the right of the corporation versus the right of a property owner downstream or someone that's affected. But the stream doesn't have any rights, and the ecosystem has no rights. So when you go to court, those things aren't even on the table. Those entities are not even, they don't even show up. It's like being in the 1830s and being a slave. You know, when there was a conflict or your slave got beaten by, you know, the slave owner down the road, that it was treated as a property damage crime. It wasn't, you know, murder of a slave was not a crime. It was a property damage action. And so you brought a property damage action against the person that beat the slave for loss of use. And rape for women wasn't a crime in the 1890s. Was not a crime. It was a property damage action because the woman was never seen in the court. Just like ecosystems are not seen in the court. It becomes a dispute between over property only. And so in much the same way, you know, people within their own municipal communities are not seen by the courts because they have no power independent from the state or federal government. And so just like that, they're not on the playing board either. And so a lot of this work is about revealing them and making them seen by the court, making them be seen by the court when those disputes erupt.
Thomas Linzey and Mari Margil of the Community Environmental Legal Defense Fund, who are changing the United States one town at a time. This interview is part of our Green Rights project. You can learn more by going to www.greenrights.com. We've interviewed numerous other people involved with environmental rights, including David Boyd, Mumta Ito, David Suzuki, and Cormac Cullinan. You'll find all those interviews on this site. For the Green Interview, I'm Silver Donald Cameron. Thanks for watching.